Okay, the recorder has started.
You want to introduce the meeting, or would you like me to?
Please go ahead.
Okay. This is the Sunshine Ordinance Task Force Education, Outreach, and Training Committee of the City and County of San Francisco. Today is March 28, 2023. The time is 6:01. This is a meeting at City Hall Hearing Room 408. Public comment. Call-in number is 415-655-0001. The meeting ID is 2492-537-7052 #. To enter the speaker number, press *3. Shall we proceed with item number 1? Item number 1, call to order, roll call on agenda changes. Roll call. Member Hill. Member Hill present. Member Padmanabhan. Member Padmanabhan present. Chair Hyland is absent today. We have a quorum. Are either of you aware of any agenda changes? Member Hill? Okay. Shall we proceed with item number 2?
Yes.
Item number 2, adoption of the minutes for the January 24, 2022, that should be 2023, Education, Outreach, and Training Committee meeting. I have a copy of the minutes. Do either of you have any suggested changes? All right. So we will move. Yes, just a moment. Shall we move for public comment? Public comment for item number 2. Any of you wish to speak?
Okay, I just want to be sure that everyone has their microphone on and is talking into the microphone. I haven't been hearing anything from the members.
You have not.
There, I
Oh.
can hear you now.
Can you hear me now? Yes.
Yes,
Okay.
yes, they can. So, anybody who would like to make public comment, you can approach the podium at this time, or you can raise your hand to the application by pressing *3 if you're on the telephone, or otherwise using the application to raise your hand. I have one hand raised at this time. I'll go ahead and unmute them, and this is public comment on the minutes.
Great. David Philpell, can you hear me okay?
Yes.
Great. So
Hang on, just a moment. Mr. Pilpel, are you ready to begin speaking?
I am.
Go ahead, sir. You have 3 minutes.
Great. Thank you. So first, as a preliminary matter, I wasn't clear in the absence of Chair Hyland if Member Padmanabhan or Member Hill was chairing the meeting. I don't express a preference. I think either one is fine, and you could probably toss a coin or just figure out. But one of the 2 members, I think, should be chairing the meeting, and you'll do a fine job. As to the minutes, yes, the agenda has the wrong year. It should be January 24th, 2023. I don't think that's a fatal error in this case. I did have one suggested change on page 1 of the draft minutes. The action on item 1, it's stated as moved by Chair Hyland, seconded by Member Padmanabhan to accept item 1A into the record. I don't think that's the best way to express it. I would say seconded by Member Padmanabhan to make the appropriate findings to allow this teleconference meeting, period. I think the rest of the minutes are fine. If I see anything further, I can communicate that to Cheryl, and I encourage you to make that amendment and adopt the minutes otherwise. Thanks very much for listening.
And thank you, Mr. Pilpel. This is Member Padmanabhan, and I am chairing this meeting today. So do we want to?
Yeah, I'll entertain an amendment to my motion as the member of public has stated.
Excuse me, I didn't hear what you're saying.
There are no other members waiting in line for public comment. I believe you can close public comment on this matter.
Thank you, Victor.
Okay.
I think the suggested change is to change the language of rather than to accept item 1A into the record, that the motion in the second was to allow for teleconference to occur.
Are you looking to amend your motion?
Yes, ma'am.
Move to approve the-
And I second it.
Do you want to call public comment again for the changes?
Sure, we can call public comment again. Yes.
My
Victor?
apologies. Did you want to reopen public comment?
Yes, please.
Yes, if any members of the public would like to make public comment, you can raise your hand through the application by pressing *3, or otherwise using the application to raise your hand. If there's anybody in the room, you can approach the podium at this time. I'm seeing no indications of public comment at this time.
Okay.
We ready for a vote?
Yes.
Member Hill?
Aye.
Member Hill, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Chair Hyland, absent. Moved by Member Hill, seconded by Chair Padmanabhan to accept the comments of Mr. Pilpel and incorporate them into the minutes of January 24, 2023. Are we ready for item number 3?
Yes.
Item number 3, public comment. Members of the public may address the Education, Outreach, and Training Committee on matters that are within the committee's jurisdiction, but not on today's agenda. Mr. Young, do we have any hands raised for general public comment?
Yes, if there's anybody who'd like to make public comment this time, you can raise your hand through the application, or by pressing *3 on the phone, or if you're using the system, you can use WebEx to raise your hand. I see no signs of public comment at this time.
So we close public comment?
Yes, we can close public comment.
Shall we read item number 4?
Yes. Thank you.
Item number 4, file number 23004, complaint filed by Amy Silverstein against Scott Reber and the Office of the City Attorney for allegedly violating Administrative Code Section 67.1A by failing to serve the public and reach its decisions in full view of the public. 67.1D by failing to let the public know what their government and those acting on behalf of the government are doing. 6724B1 I-1 through I-2, by failing to provide information on litigation materials, 67.36, by failing to allow the Sunshine Ordinance to supersede other local laws.
Hi, this is Victor, running the remote system. If there's anybody online who is associated with this matter, if you can raise your hand just so I can identify you, it would be appreciated.
How much time do you want to give the speakers?
5 minutes each. That's what
5
we've been
minutes,
doing.
okay.
Okay, I don't see any hands online, but you can go ahead and proceed and we can find out if there's anybody else associated. Thank you very much.
Okay. Do we have Amy Silverstein here?
Yeah. Hi, I'm Amy.
Are you ready to begin, ma'am?
Sure.
So we give each of you up to 5 minutes to tell us about your case. And after that, we will discuss the matter among us here on the panel and then come back to you for rebuttals.
Do you discuss it in public or?
We do discuss it in public.
Okay, great.
Yeah.
Okay,
You ready?
sure.
Go ahead.
My name is Amy Silverstein. I'm a lawyer here in San Francisco, and I've been practicing state and local tax law for over 30 years. I represent taxpayers of every size, from the smallest businesses to the largest ones, and I represent taxpayers against governments, including the state of California, other states, and local jurisdictions all throughout California, including, of course, San Francisco. Of all of these taxing jurisdictions, San Francisco is probably the most secretive jurisdiction and that I've encountered, and it also has some of the most onerous taxes and tax penalties, and it's very aggressive in its enforcement. Most tax authorities publish extensive regulations, legal rulings, notices, and other publications to give taxpayers and their counsel guidance as to how they interpret, the cities interpret and apply the law, but San Francisco has almost none of this. And it's also notoriously aggressive in its litigation. And so it chills taxpayers from challenging decisions against them by the city. And as a result, there's very little tax or case law helping us to represent our clients. So in light of all of the secrecy in San Francisco in the tax administration, I am trying to get the Sunshine Task Force and the Sunshine Law to provide some transparency to how San Francisco is administering its laws. And of course, you know that the Sunshine Act is very broad. I could have asked for a whole wide variety of types of documents from them, but I requested only 2 types of documents that are specifically provided for and mentioned in the Sunshine Ordinance, and that is claims for refunds by taxpayers and settlement agreements that the city enters into with respects to disputes with the city taxpayers. The city gave us some settlement agreements, but they didn't give us all settlement agreements, and they didn't give us any claims for refund. And as you know, the Sunshine Ordinance has many provisions that indicate that its provisions should be interpreted in favor of disclosure. There's a strong presumption in favor of disclosure, and there's a California constitutional provision that also requires the city's laws to be interpreted strongly in favor of disclosure. And so I'm not going to get into all the details because, of course, you know that. But the bottom line with respect to the city's position is that it's concerned about confidentiality. Okay, I have responses to all of their technical arguments, but all of them are addressed. All of them come down to confidentiality. So basically, the city, they already provided some settlement agreements, and these are settlement agreements for cases that went to litigation. So the taxpayer filed a lawsuit, and then the case settled before there was a decision, and the city gave us those settlement agreements. The city says they gave us those settlement agreements because the taxpayer waived confidentiality by filing the lawsuit. So by definition, that also means that the city has conceded that they should give us the claims for refund in the cases that went to litigation. Because if the taxpayer waived confidentiality as a result of filing a lawsuit, and therefore the settlement agreements are not confidential, then also the claims for refund should not be confidential. So I think that takes part of this case off the table. They haven't given those to us yet, but I'm hoping the task force will find that they need to give them to us under the Sunshine Ordinance. And what that leaves is claims for refund and settlement agreements for cases that have not yet been filed in court. So they settled before the taxpayer filed in court. And the confidentiality concerns that the city raises can all be addressed through redacting the documents that I'm looking for. So basically, the city says that there is no exemption from prohibition on disclosure if the taxpayer's name and tax identification number are on the document. And of course, this cannot be the case. If you have a 10-page document and it has the taxpayer's name and ID number at the top, it can't make the whole document confidential, right? Is that 5 minutes?
Yeah, 30 seconds.
Oh, so basically, what I'm arguing is that if they just redact the confidential information, then the confidentiality concerns go away. I wanted to show you a claim for refund because I think they're misleading you as to what's in it. There is identifying information. I can give you copies of this if you allow me.
Yes.
Okay, so basically, sample so you know what we're talking about. So basically, it's a simple form that does have information about the taxpayer on it that can all be redacted. And then there's a space that says basis of claim. And so some claims are as short as just a few sentences. And some claims have longer explanations attached to them. And I provided you one to show you how it can be redacted. The city's concerns about tax returns being attached and confidential agreements and all that sort of thing, that's almost never the case. It's almost never the case that those sorts of documents are attached to a claim for refund. And if they were, they could simply be redacted and taken off. What would be left is information about the substance of the claim, the legal grounds, the statutes that are being cited, and that sort of thing that would give me and other practitioners information about the underlying substance of the dispute so that when you looked at the settlement agreements, you could also see how the city was resolving these cases. And if you just look through the document that I provided, you can see that the names are redacted. We redacted quotes from a taxpayer's 10K that might be.
Can I stop you there? Is that part of the packet? Have you attached this sample to the packet? Liz, have you?
I did not. I just wanted to use it as an
Okay.
exemplar.
All right.
5 days before.
I know.
Shouldn't have given it to the pen.
Okay, okay. The point I'm trying to make is that claims for refund sometimes are very brief. There would be, the only thing that would need to redact it is the name, the taxpayer's ID number, address, and the amount at issue. And then if there are other things attached, on a case-by-case basis, they can be removed if they would help identify the taxpayer. And that would resolve all of the arguments that the city's making as to why these particular documents shouldn't be disclosed to the public. I'm happy to answer the technical arguments that they made, but again, I think that all of this comes down to confidentiality and all of it can be addressed through redaction.
Are you done with your testimony? Yes. Cheryl, do we have anybody? Do we have anybody? Oh, okay, good.
Wait, I'm sorry. Did we want to? Is this the moment where we ask if there are other people that are here in supportive of?
Yeah.
Oh, okay.
Yeah.
Not the attorney's office, but is there anyone here in support of Ms. Silverstein? Okay, thank you.
And your name?
Jen Court, the City Attorney's Office.
Jen.
Hi. Nice to see you all in person for the first time.
You ready? Are we ready for Ms. Court?
Yes, you may begin.
Okay, you'll have 5 minutes. now.
Okay, great. Good evening, members. Jen Court on behalf of the City Attorney's Office. So the petitioner is correct. This all does come down to confidentiality. Taxpayer information is among the most sensitive information that the city handles. So the request seeks confidential taxpayer information. Our office declined to disclose that information because multiple state and local laws state that that information is confidential, explicitly confidential. We did, as she mentioned, we did try to provide some sort of information that we felt we could legally disclose. However, I think that's, as you heard, not all of the information that they're seeking here. To start with just kind of the basics, tax information is self-reported to the government and self-reported to the taxing agency, and the taxing agency ensures confidentiality. That confidentiality incentivizes the taxpayer to accurately report their business activities for taxing purposes. Part of that process is that the confidentiality, part of that process and the confidentiality is that the taxpayer has an ability to ask for a refund if they do believe that they've overpaid. The taxing entity communicates at multiple points throughout that process that information will remain confidential. The taxpayer understands that information contained in those claims will remain confidential unless they choose to pursue litigation. This incentivizes many of the claimants to resolve those issues at the claim stage because they don't want to go to litigation and disclose this information or have the public or their business competitors have access to their confidential information. And I think it's important that mostly what we're talking about here is taxes related to business entities. It's not really individual taxpayer information. So just to go on, California Government Code 7295 exempts any tax information from disclosure that would result in an unfair competitive disadvantage to the taxpayer. And that would clearly happen here because if information was disclosed, business competitors would be able to access highly sensitive information about the operations of another business that would result in an unfair disadvantage to that taxpayer seeking a refund. And also, San Francisco Business Tax and Regulations Code 6.22-1 confirms the expectation of confidentiality for the taxpayer. And this section of the tax code does not allow for any sort of partial disclosure of tax information. Additionally, California Evidence Code 1040 prohibits disclosure of information acquired in confidence by a public official. This information fits that definition. There's an argument to be made that these records must be disclosed because they represent pre-litigation claims against the city, which is included in the Sunshine Ordinance. However, these are not actually pre-litigation claims because rarely do they ever go to litigation. Most of them are resolved at the claim stage. Aside, two things that I would say. One about redaction. The problem is that most of these settlements have to go to the Board of Supervisors to eventually be approved. And so even if you were redacting the name and the tax ID, that sort of thing that would remove some sort of identifying information, once it goes to the Board of Supervisors, you would be able to essentially match up the underlying facts of the redacted claim form with the name and the settlement amount and the tax that the business is receiving a refund under to the underlying claim form. So it doesn't, aggregating the data in that way or aggregating the information doesn't really solve the problem of confidentiality. And lastly, I just want to acknowledge, or two things. One, this would be a big departure from how other taxing entities in the state and country, if we were to disclose this information, operate. And then lastly, I do want to acknowledge we have many substantive objections to this, but in terms of jurisdiction, no objection that the task force has jurisdiction here. So thanks. With that, can answer any questions.
All right. So this is the point where we ask questions. Member Hill, do you have any questions? I have a few, so.
Please.
So maybe I should start. I'll jump in. For the respondent, Ms. Quart. So you mentioned pre-litigation claims, and I've seen that term mentioned throughout. And you mentioned also that it is possible if the claims had not been settled, that it could go to the courts. It could be litigated. Is that right?
Well, that's ultimately the taxpayer that's making the claim. That's their choice. A lot of these cases, most of them are resolved at the claim stage without the taxpayer having to file a lawsuit and pursue litigation. So they absolutely can go to litigation, and once they do go to litigation, that information is public. It's part of the court record.
Okay.
But yeah.
So what is your definition of pre-litigation claims then?
It would be a claim that results in litigation.
That results in litigation?
Yeah, because otherwise, if pre-litigation wasn't in if that term pre-litigation wasn't, there's a reason that pre-litigation is in the Sunshine Task Force, the Sunshine Ordinance's language. Otherwise, it would just be all claims. Okay. You know, the city receives many claims, not just tax claims that are settled at the claim stage. So there is a difference there.
And you also said that, and you mentioned it in your statement too, that in rare circumstances, these claims could go to litigation. So there is no guarantee. I mean, there is no way of knowing beforehand if a claim does go or doesn't go to litigation. So at what point does it become pre-litigation? Only
if litigation is filed.
Only if litigation is filed?
Yes.
I see. And why is partial disclosure of taxpayer information not authorized? You mentioned about looking at being able to compare with the settlements once it goes to the Board of Supervisors. But what if it doesn't?
Sure. I think there's kind of two separate issues there. I mean, there's the practical implication of you could match up the underlying facts with the taxpayer's name if it does go to the board. But just from a general perspective, the San Francisco Business Tax and Regulations Code, it's 6.22-1, specifically subsection A, but really all of it. There is no allowance for partial disclosure. It is very clear that taxpayer information is confidential. There's no allowance for a partial disclosure of anything. Okay. And I think too, just if I could, I think we would even have concerns of even if in a claim form, the name and the tax ID and things like that were redacted and say it doesn't go to the Board of Supervisors, there's still things in that narrative that I think would be considered confidential taxpayer information. So things about how they run their business, revenue streams, within their business, what has been, where revenue within their business is generated and where it isn't, that could result in another business seeing that information, and that would put the taxpayer who filed this claim at an unfair disadvantage. So I think there is even stuff within that kind of narrative that we would have confidentiality concerns with, for sure.
And what if you redacted that too?
I think if we redacted all of that, what we would essentially be left with is a blank claims form, which I don't think is useful to anybody,
Okay, thank you. I have some questions for Ms. Silverstein.
Could I possibly quickly respond to what she just said?
Okay, yeah, sure. I'm going to ask you the exact same question, which is how do you define pre-litigation claims? Because I believe that you have a different definition.
I do, absolutely. So I start with the principle that the Sunshine Ordinance needs to be construed in favor of disclosure. And it needs to, and the Constitution requires that too. I cited that in the document. You're probably familiar with it. And so to me, pre-litigation claims just describes a claim for refund. It's something that you have to file before you can go to litigation, whether or not you do. And so by analogy, it's kind of like, I'm Amy. You could call me Silverstein. You can call me Amy Silverstein. I'm still the same person. So to me, pre-litigation claim is just describing this claim that needs to be filed before you go to litigation, whether or not you do. So I think it describes all of the claims we're talking about.
Right.
So, and really all that matters, you know, when you decide what's included in that is that pre-litigation claims are, per the Sunshine Ordinance, it's mandatory to disclose them, whereas all other claims still need to be disclosed. They just don't have this enhanced status. And so really, with all of them, you do get back to confidentiality. And I wanted to push back on what the city attorney said about the tax code provision on confidentiality. So it does say, except as otherwise provided by law. So it's not absolute. And it does contemplate, you know, some exceptions. We can debate what they are, but it's not absolute. And then when you look at the Sunshine Law, that actually prohibits disclosure of a document in full. It requires disclosure to the extent that the law allows. So if there's something in the document that's confidential under the Sunshine Law, you should redact it and provide, you know, the remainder of the document. And I would completely disagree that redacting like trade secrets and information that could lead to a competitive advantage would render the document useless, because, as I said, some documents are very brief and there's not much in them at all. But to the extent that they're more robust, a lot of it often is legal argument, nothing about the taxpayer at all, or very little. And it may be, you know, fairly high level. It's not something that would either allow a reader of the document to identify the company, let alone get some kind of competitive advantage out of it.
Okay, thank you. So let me understand. So you were offered the settlement agreements that were litigated.
Correct.
Have you received them?
Yes. Well, yes.
You have?
Yes.
Okay. So are you looking for claims that have also been litigated, or are you looking for all claims?
Well, all claims. And
All
so
claims.
a subset is the ones that have been litigated. And I would submit that they already said that the taxpayer waived confidentiality. So
Right.
I think those we should get just automatically.
Right. Okay. That's it for now. Member Hill?
Thank you. Maybe one of you might be able to answer this question, but I'm just curious about, like, how many do you know maybe approximately how many claims that you might be missing? I know that you don't have that. Like, is there a general? Is it one? Is it a dozen? Is it 100? Would you know?
But it is not a small number. The city in general, I don't know how many tax claims specifically, but
Okay.
the city in general receives thousands of claims per year.
If you're going to speak, you will ask that you come to the microphone.
I'm sorry.
Because, I cannot
Yeah.
hear it, and it's not
My
recorded.
apologies. We're
Sorry.
all sort of new at all these positions right now, so we're doing our
Say
best.
that one more time. One, off the top of my head, I have no idea how many
Okay.
specific tax claims there are, but the city receives in general thousands of claims per year. So I would wager to guess it's not a small number.
Okay, if you could
Oh,
remain,
okay,
I just
yeah,
have one
yeah.
more question. You mentioned earlier that you said that this would be like a departure from a typical mode of operation.
Mm-hmm.
Could you maybe go into a little bit further in detail as to, like, could you just explain that further, please?
Yeah, just, from our perspective, we don't know of a taxing entity that would, provide confidential taxpayer information anywhere. I just,
I
yeah,
understand.
yeah.
I guess I'm still just trying to, I am still trying to understand, if I'm drawing from personal experience. I respond to RFPs all the time where I have to include financial information, and usually like when someone FOIA requests that kind of stuff, I'm given, as a business entity, I'm given the opportunity to redact things like trade secret and that type of stuff before that stuff goes out. So that's part of the reason why I was asking the question, was because because normally like that's kind of my experience of like when someone requests information that has to do with my business, I get reached out to by the government entity, and then they give me the opportunity to redact it, and then ultimately my financial statements get sent out to my competitors all the time, it's it's the cost of doing business with government. Right. So I was wondering maybe you could address that.
So I think a couple of things. I'm trying to find exactly where it is, but so these tax refund claims, they're received by the city attorney and the tax collector, and it's not just the refund claims, but it's also just the information that taxpayers provide to a taxing entity for taxing purposes. They have to be quite candid. So on the front end, there's no opportunity to redact it for the treasurer and the city attorney. You know what I mean? There's that doesn't really exist. But also, I would say there is in the Business Tax and Regulations Code for the city, it's 6.15-1B, specifically subsection C, or I'm sorry, subsection 3. The grounds upon it basically says that if you are submitting a refund, a claim for refund, you have to provide enough specificity sufficient for the tax collector to, make a determination. So there is, even required by law, taxpayers do have to submit quite a bit of specificity and information in those tax claims. So I think I answered.
No, that helps. I
Okay.
appreciate it. And
Okay.
one more question,
Yeah.
and thank you for your patience and to my questions. Could you just so I understand this clearly? Could you I understand that there were some claims that were litigated that you now have that you don't have in your possession. What were so? Describe the difference between the ones that you do have in your possession and the ones that you don't. Or you could also answer
I honestly think she would know
okay,
better.
all right.
So the only thing we have in our possession is settlement agreements that
Understood.
relate to cases that proceeded to litigation. So a case was filed in court.
Yeah.
We don't have settlement agreements that were settled before filing in court.
Yep.
And we don't have any claims for refund. So claims for refund could also relate to settlements that were reached before court, or they could relate to cases and settlement agreements that proceeded to court, or maybe weren't even settled. With respect to the latter, when they proceeded to court, my position is that the city said, you understand that, the taxpayer waived confidentiality, so we should get those, but I don't have them yet.
Right.
Does that answer it?
It does.
Okay.
I have one other question
Sure.
for you. You had mentioned in the beginning of your statement that that in your experience that this tends to be, less giving as compared to your work that you do with other agencies. Could you give a specific example of maybe another jurisdiction or municipality that you've asked the same thing for and gotten a different kind of result?
Well, what I was referring to really is that in San Francisco, basically all you have is the code that tells you whether to pay tax or not. You don't have like regulations and rulings and other things that show how the city interprets and applies its code. And then what even compounds that is that if you have a dispute with the city and they disagree with you, they say, no, you lose. They don't tell you why. So you basically are like, okay, I have no idea why you disagree with me. I can't go out and find any law. And then a lot of taxpayers are afraid to go to court because the city is ruthless. And they have this scorched earth approach that makes it so expensive, and you don't know why they disagree with you in the first place. So everyone's afraid to go to court. So then there are no court cases. So we're basically just trying to get more transparency. And so the first place I thought to look was the Sunshine Ordinance and this task force. And so instead of asking for the city just to open its files, I thought, okay, claims for refund and settlement agreements are mentioned in the Sunshine Ordinance. So let's start there, right? And they gave me some, but then they said, no, confidentiality. And of course, the city attorney keeps saying that, but I'm not asking for the confidential information. I'm just asking for really the grounds that are not even very specific to the taxpayer. So take out their name, take out, their business secrets, take out, anything that would help me identify who they are. I don't care who they are. Mm-hmm. I'm just trying to get more transparency about what's going on in their office, because there's so little guidance out there, and it makes it very hard for my clients and me to know how to comply with the law.
Thank you. I appreciate that. So what you're saying is, you haven't asked for refund claims from another agency and have been successfully able to get that from another agency. I was interpreting that a little.
Yeah, I didn't quite answer your question. So, the other agencies, they have regulations, they have rulings, and maybe most importantly, they tell you why they disagree with you. So you could get a long document that says, you said this, we say this, we think the answer is that. And then you have a roadmap for why they disagree with you. Mm-hmm. But you don't get that from the city. And so we're just looking for other ways, to get this information. And so I guess the answer is we don't really need that from other jurisdictions because they're so much more transparent to begin with. Does that make sense?
It does, but I guess, what we're trying to, I think what we're trying to figure out here is, the basis that you're making is the notion, is the statement in the Sunshine Ordinance that says pre-litigation claims against the city, which I think that kind of everybody is agreeing that's fair. But what's not necessarily what's kind of up in the air is that these are particularly claims for tax refunds. And it's that combination of the fact that it's like a claim that includes tax information that I'm having a trouble discerning the difference between what's mentioned here, pre-litigation claims against the city. I understand what you're saying. That's why I was asking the question about the volume of work, because then it gets into, okay, well, we might all agree that, that we could give you redacted versions of all, claims for refunds, but that could be thousands and thousands of documents that then we would be asking the city to possibly redact in order to give to you. But I'm wondering, again, I'm trying to go down a line of thinking.
Right. No, that's fair. So I guess a couple of reactions. One is with respect to the cases that have gone to court, I think that's relatively small because they gave me the settlement agreements and it wasn't a lot. So I'm assuming that there may be more, but not a lot more. And I guess I don't know the answer necessarily to the volume on the other side.
Pre-litigation.
Maybe we limit it to a certain type of tax. I mean, I don't have that information, but I guess just to go back to your question about the pre-litigation claims, what was I going to say? Well, I lost my train of thought.
It's okay. I think I have everything I need at this moment, but I mean, something else may come up, but thank you for that. I would love to give the Attorney's Office an opportunity to also respond to that, to my comments as well, if that's okay.
Okay. I guess, just the only last thing was that, again, I totally get the intersection of the tax law and the Sunshine Ordinance, but again, we're not asking for the confidential part of it.
Yes,
Okay.
understood.
Thank you.
Thank you.
If I could just respond to two things, if possible, if that's okay.
Okay.
So the first thing, I think, what it sounds like to me that the petitioner is seeking is general information about how the city reaches certain tax decisions. But that to me is kind of a policy decision. It's not necessarily a public records decision, if that makes sense. That's a policy decision of policymakers to put something like that out. It's not necessarily the specific records that we're talking about in question right now. And then the only other thing I wanted to say about claims, which well, two things. One, it really is that combination of pre-litigation claims plus tax information, plus tax claims, because we give out pre-litigation claims on other topics all the time. We release that constantly. We are very clear that's a public record, but it's the intersection of that tax information that make this situation different. And then I would just say in the Sunshine Ordinance, where it does talk about pre-litigation claims, 67.24B1 and then subsection I, you know, at the top of that section, it says notwithstanding any exemptions otherwise provided by law. And we have tons of other areas where, you know, the law says tax information and tax claims are confidential. So that's kind of why, you know, we see this as different than other pre-litigation claims.
Okay, I do have, I'm sorry, did you have another?
One last question.
Go ahead.
Yeah, no, I apologize. Okay, so with these claims that you get, claims for refund, the information that's filled out on those forms, is that information aggregated anywhere? Do you know, is there, I know that, I'm just going to make it simple. Is there a spreadsheet somewhere that aggregates this information about the date that they came in, the amounts that they, you know, that they're requesting, like what it's about? Like, do you understand my like where I'm going with this?
Yeah. So, I mean, to answer your question, no, there's no spreadsheet. That's a record we'd have to create for sure. But what is available to the public is basically when tax settlements, when it reaches the settlement stage, whether that's pre-litigation or whether that went to litigation or it was settled before litigation, those settlements do have to go to the Board of Supervisors. And what is made public at that point is, one, the name of the taxpayer, two, the settlement amount, and then three, the tax in which the refund is being given under, the specific tax. So for example, like gross receipts tax or something like that. So that is what is made public. And I don't think we would have any problem creating a record of that specific information over a certain amount of years. I think we would do that. But, you know, again, it is limited information. It's really just three pieces. So
when you receive a claim, when you receive a claim in, you're not entering that somewhere, that information somewhere.
No, it's more treated like each
The whole
little claim is
document.
its own case, and we have to consider the individual issues in each claim. We're not really looking at it in the aggregate like that, I guess.
Understood.
Yeah.
Thank you.
Yeah.
That's thank you.
Okay. And so I'm going to go back to the claims that have been litigated.
Yes.
Now, is it possible for you to release those to the petitioner?
So that's a question, to be honest, I would have to check with my colleagues. I can't give you an answer on that right now. And honestly, I think she has a better accounting of what exactly has been released to her than what I do currently right now. But I think that's something we could get back to the task force. And if this does move on to the full task force, like something we could be prepared to address.
Okay. So I just want to be clear about what the general case is, because you mentioned that most claims are not litigated. Only in rare circumstances are they. And so what is the process? What is the general case? What happens?
Well, I mean, I think it totally depends on the level of complexity that a claim for refund comes with. But essentially, we get a claim, we have to work with our client departments, the treasurer, et cetera, to kind of understand, is this claim for refund valid? Did the taxpayer actually overpay, right? And then depending on that, we'll try to have engage in conversations with the taxpayer if they're, to try and figure out a settlement. If, for example, we can't reach a settlement agreement, or, the taxpayer disagrees with our assessment, they might choose at that stage to file a lawsuit. And then, it would, yeah.
And you mentioned a spreadsheet, but wasn't it a spreadsheet that you released to the petitioner?
Yeah, we created that. That's
created
what
that.
that's what I'm saying. We created that.
Okay.
Yeah.
All right. I think I have all my information.
Thank you.
All right. So should we move to rebuttals?
Yeah.
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 absolutely.
Okay. So we have.
Who want to go first?
I think we do it in reverse order. Yeah. And we allow, what is the protocol, about 3 minutes, 2 minutes? 2 minutes. This is just a wrap up. And
Yes, I'm ready. Thank you. I don't think there's too much more to discuss. I think the only thing that we haven't really gotten into is just the amount of specific laws that explicitly state that this information is confidential. So those are all cited in our documents that we submitted to you, but there are several laws that claim that this is confidential information. And there are also several laws under the CPRA that we are allowed to rely on in this instance that, provide that exemption necessary under the Sunshine Ordinance to withhold this information, essentially. So I think the only thing we really haven't gotten into is just kind of all those little different citations and laws, but I think you guys can read that for yourself.
okay.
That's all. Thank you so much.
Yeah, I did want to say that, most of this is in the document that I provided to you all, but we strongly disagree that those various, what they call exemptions even apply. So like, for example, with pre-litigation claims, if you read the Sunshine Ordinance, it actually overrides because it has these enhanced provisions compared to the CPRA. So it overrides the CPRA. And then there's other reasons that the various exemptions, they call them exemptions from the CPRA, just don't apply here. But one more time, they all can be addressed through redaction. Thank you.
Thank you. All right. So
I have thoughts.
I do believe that the records do exist, and it falls under the jurisdiction of the task force. And I think it would be good to have the task force discuss pre-litigation claims. I think the whole crux of the matter lies on, definitions of pre-litigation and the various interpretations of that. And at the least, I think the attorney's office can release the claims that have been litigated.
Mm-hmm.
So I do think we need to send it to the task force. What do you think?
Yeah. So, it seems like to me that everyone seems to be in agreement that we don't want to expose personally identifiable information, number one. And we don't want to expose, that in direct relationship to, sensitive financial information. To me, it feels like that if there were claims, and there were 5 of them, that we could all probably agree that we could easily redact those, redact the information that the city feels is sensitive, and be able to call that a valid public records request as long as the information had been the sensitive information had been redacted. Because I just don't see any other reason why not. So to me, because I have to sort of like take that lens of like, if it's one and we did it, everyone would be pretty much in agreement with that. Maybe not. Like it seems to me that like a claim without the tax information, without the personally identifiable information, as long as we weren't releasing it leasing other financial information that would be confidential. While I understand that in some cases might not lead to much being left, I do feel like that there would still be information that might be pertinent. And it's that reason why I agree with you that I feel like we should allow the full board to hear this, because there is this sort of area of are the claims actually FOIA-able, so to speak. So I would agree with that assessment as well.
Okay, so should we go ahead with the motion?
Yes, please.
You were beginning a motion.
Okay, I can
beginning
go
a
ahead with the
motion.
motion. So,
Do you want me to tell you what I have so far?
I'm sorry?
Would you like me to say what I have so far in your motion? Or you want to change what?
I can, okay, what do you have so far?
I have moved by Member Padmanabhan that the records are public, there is jurisdiction, and to send the matter to the task force to discuss pre-litigation and if the city attorney's office can release the claims that have been litigated.
I think, and find a violation of 6724B. We should just, or would you prefer to just leave it at without the violation?
One moment, Madam Clerk, sorry.
Did you,
I'm just thinking for just a second.
did you want to make a change or?
Or we could just leave it at refer the matter to the task force with a recommendation to consider the interpretation of pre-litigation claims.
Yeah, I would prefer not to have a recommendation, not to make that last statement.
Yeah.
Pre-litigation. To discuss pre-litigation claims.
That's it. To consider the interpretation of pre-litigation claims.
We apologize, but we'll have to ask you to come back one more time for the full board. No, I'm just saying generally that's we have a little bit more investigation that we're going to do on this, but thank you for your patience.
And just so that everyone knows, participants are allowed to participate via our remotely or for the time being, if that would be easier for them.
Thank you, Victor.
Are you ready to move to public comment?
Cheryl, are we ready?
Yes, we're ready.
Okay, yes,
we are.
we can move to public comment now.
Yes, if there are any members of the public who would like to provide public comment, you can do so at this time. If you're in the room, you can approach the podium. If you are on the system, you can press *3 to raise your hand. I'm going to go ahead and unmute our first remote public commenter.
Great. David Pilpel, can you hear me okay?
Yes, we can.
Excellent. Okay. So the petitioner, Amy Silverstein, I do know. I went to school with her brother more than 40 years ago. I have not spoken to her about this case. I did attempt to contact her, but I've been unsuccessful, and we might discuss it between now and the full task force. So I've not talked to her about it. I think this is a pretty important case here tonight. I think it's pretty well agreed that pre-litigation claims are subject to disclosure under 67.24B1 I or 1. In my opinion, the San Francisco Business and Tax Regulations Code, and in particular, section 6.22-1 talks about the tax collector specifically not the controller or the city attorney's office. And generally, my understanding is that claims against the city are filed with the controller's office and then are reviewed by the city attorney. The tax collector, as in any other city office, may be involved, but they're not the primary office. It's the controller and the city attorney. So I agree that the issue here is redaction. I don't believe that this is a 6255 balancing test issue, which is now codified at 7922.000. Nor do I think that this is an evidence code 1040 issue. This is not about information acquired in confidence in the way that evidence code 1040 is normally construed, in my opinion. The records do exist. I think they are likely subject to disclosure, but they may be subject to partial redaction, as has been pointed out. The current 7925 language about competitive disadvantage does not prohibit disclosure. It says that this division does not require the disclosure. So in my opinion, 7925 makes it permissive. There may need to be privacy balancing here, which is not a 6255 balancing, but privacy balancing, which is allowed, but it should be narrow. The public interest in fair taxation is high, including the disclosure of tax claims and tax settlements. Tax claims are filed by taxpayers, i.e. they are initiated by a taxpayer. They are not initiated by the city. I disagree with the city attorney's proposed approach here. I do not believe that disclosure is subject to a court order to release. I think we've got plenty of code sections here that talk about how the process runs, and it's not that you go to court and only if a court of competent jurisdiction orders release would the city attorney so disclose. That is not the way this works. And finally, as was pointed out, Section 67.36, the Sunshine Ordinance supersedes other local laws. The provisions of this Sunshine Ordinance supersede other local laws. Whenever a conflict in local law is identified, the requirement which would result in greater or more expedited public access to public information shall apply. And to the extent that the Business and Tax Regulations Code and the Administrative Code are both local laws, I believe this provision, which was enacted by the voters in 1999, supersedes, and therefore...
Your time is up.
All right, you get my point. I thank you very much for listening.
Thank you.
Thank you, Mr. Bilbao.
Okay. I do not see any additional hands raised at this time. I believe we can close public comment.
We ready for a vote?
Yes, let's go on to vote.
I'm sorry, could you repeat the motion? Just
That the records are public, we have jurisdiction, and to send the matter to the task force for the task force to consider interpretation of pre-litigation claims.
Yeah. Did we vote on it? Did you second my motion?
I think you did, yeah.
I did.
Oh, you did.
Yeah,
Okay.
you
Okay.
did.
All right.
Did I get it correctly?
I'm sorry.
Was the motion correct?
Yes.
Okay.
Thanks.
Let's go to vote. Member Padmanabhan.
Aye.
Member Padmanabhan, aye. Member Hill.
Aye.
Member Hill, aye. Chair Hyland, absent. 2 votes in favor.
Excellent.
Thank
So we
you.
can move on.
Thank you
to
so much for
Thank
for
you,
presenting.
everybody, for your time.
You ready for the next item?
Yes, thank you.
Item number 5, file number 22023, complaint filed by Lance Carnes against Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner.
So we can start with the testimony of the petitioner,
Mr. Carnes?
Mr. Carnes.
Yeah. Before you begin speaking, sorry,
I'm sorry?
I want to check with our clerk Young. Oh, good. So we've got the slides that, those are your slides that you,
Let's see.
I just wanted to confirm what Mr. Carnes needs. That's it?
Vision's kind of,
That's okay. Okay.
Okay.
All right. So are you ready?
So you have 5 minutes? Yeah,
Yes,
just
you do have
let me
5
get
minutes.
this.
Are you ready,
piece
sir?
of
Do you need
paper.
a minute?
I'm sorry?
Are you ready? Do you need a minute or?
Just a sec to get my,
Sure.
I dropped all my notes. So. Okay. Okay. Thank you for indulging me.
I'm sure.
It's,
Let me know when you're ready to begin.
okay. So, okay. You hear me okay?
Okay, you got 5 minutes to speak.
And how do I advance the slides?
Those are your slides.
Huh?
You'll need to give me an audio cue.
I'm sorry?
You'll need to tell me when to change slides.
Oh, okay. Let's see. Okay. Let's see if we can try this. Okay. So would you, let's see. So the first slide's up. I can just start. Okay. Good evening, committee members. My name is Lance Carnes. I'm a resident of North Beach and a longtime tree advocate. I have fought tree removal battles with DPW since 2019 to try to keep as many trees in place as possible. San Francisco has one of the smallest tree canopies of any major city in the U.S. So here's the next slide.
Please pause the timer. I'm trying to figure that out right now. It's not moving easily for me. Oh, there it goes. Thank you. Please
Okay.
proceed.
We're back on. Okay. So here's a brief summary of what happened during. There was a problem with 32 Market Street trees that came up on my initial public records request, and these trees were supposed to be removed to make way for BART entry canopy covers. So I sent in a request. I received it in time. In September 2021, I later learned that 4 of the 32 trees on the list were not pertinent to the request. In December 15th, the list of trees was further altered by DPW in the course of the Board of Appeals hearing. Board of Appeals voted on and accepted the altered list, not the original list returned per the public records request. So the final list that was voted on had 33 trees, not 32 as in the original request. Let's see, next slide, please. Maybe I can just give you a number. Can you go up to slide 22, please? So here's what I'd like this committee to do. I've determined that from public records request 23-1456, that at least 3 and possibly more emails were from unknown senders, contained erroneous information, and now exist in the DPW archive. I would like these and other similar emails to be expunged so that I and other citizens requesting information from DPW will not see this misleading information. And the next slide, please. What I would like this committee or someone in Public Works or the city attorney's office to do, locate the mysterious DPW employee who sends emails posing as other DPW employees and remove that person's ability to do so. The DPW employees who are affected, and in other words, these are people who are on the staff, and people in the public like myself received emails with these people in the from part of the email. So I would believe that one of these people, Carla Short, David Steinberg, Nicholas Crawford, Susan Nodberry, Brian Ong, had actually sent me an email. And then when I checked further, I'm an IT person. I've been in the business for 55 years, but I've never had to do forensics. But I did find a way to figure out whether the email was sent from the person who was on the list here, or whether it was somehow, slipped into the stream by someone else. And I think about every email I receive from DPW now, I go, oh, okay, I know that. It's David Steinberg. He's a good guy. He probably. And then I look in the email. There's a like a fingerprint that tells where the email came from. And I look at it, oh, that wasn't David Steinberg. And so I've probably received, I don't know, hundreds of documents from DPW, and I've gone through a lot of them, and I'd say about half did not come from the person who was on the from part of the thing. So anyways, I'd like someone either this committee or Public Works or City Attorney's Office is to locate the mysterious person who sends these emails and remove that person's ability to do so. Thank you. So do I just take a seat again?
Yes,
Okay.
please.
Thank you.
Now, is there someone on behalf of Mr. Carnes, in support of Mr. Carnes here? Or online? Victor, is there anyone?
If you are in support of the complainant, if you can raise your hand, we have one caller on the line. They have not indicated that they would like to speak at this time.
Okay, thank you.
You ready, Mr. Steinberg? Go ahead.
Thank you. Excuse me. Good evening, Acting Chair Padmanabhan and Member Hill. It's nice to see you both for the first time. My name is David Steinberg, and I am custodian of records for San Francisco Public Works. I'm responding to this complaint on behalf of the department, and we also have Chris Buck, the department's urban forester, who can answer more technical questions about BART's tree removal application and how we maintain our tree database. If you have any questions. As we wrote in our response, Public Works acknowledges that it's subject to the Sunshine Ordinance, and the records Mr. Carnes have requested are public. Mr. Carnes acknowledges that we responded to his request in a timely manner. Mr. Carnes has submitted 238 requests to Public Works in the past 3.5 years, and I've worked with our Bureau of Urban Forestry to diligently respond to all of them. Mr. Carnes' main complaint, as he filed it, is that the records provided to him were inaccurate. Although there may have been some disagreements over the numbering and identification of some trees, in no case did the department withhold records. Each time the department released records, we did so as they then existed in our tree database. As far as the allegation that records we provided were fabrications or forgeries, I haven't seen any evidence of this. And regardless, the task force wouldn't be the proper forum for lodging that type of complaint. I'm happy to answer any questions. And again, Chris Buck is here. He can answer questions that were raised in the initial complaint about numbering and database.
Okay. Well, would you like to, Mr. Buck, would you like to speak up right now, make a statement, or?
He was basically just here to, he can answer the technical
Okay.
aspects of what Buff does.
Okay. Okay,
So if you have questions.
fair enough, yeah. So now it's our turn to ask questions. So,
Please.
please.
I
Okay, all right. So my questions, I'm going to start with Mr. Carnes. So at this, so just to be clear, you got all the records you requested. Am I right?
I got 32 records. That's correct.
You got 32 records.
Well,
But there were 33 that were submitted to the Board of Supervisors.
Board
all
of
right?
Appeals.
Board of Appeals, yeah. So have you, and you said there were 4 that were in error. 2 of them, as I understand, had already been removed, one in 2019 and one in 2016.
That's correct.
And there were 2 that were incorrectly located, or the numbering was off. Now, how would you explain that? Is the numbering off, or was it, why do you think those trees made it to that list?
Okay, well, this is my geeky side. I'm a mathematician and computer scientist. Anyway, the DPW database has 2 ways of identifying trees, or at least 2. One is by address and what's called a site number, which is very difficult to pin down. The other way is by latitude and longitude, which I prefer. You don't have to wonder what address you're at or whatever. You just right there on the spot. So the way I determined those trees were not correct is I drew a map. I could show it to you if you like, but we had to dig it out. It's so the trees were, if you went down and took a look at them, where the longitude latitude pointed to, these are 2 small trees next to a muni bus shelter. So they wouldn't need to be removed to put up canopy covers.
Okay. Now, so let's go back to the 32 trees and the 33 trees. So there was 1 extra tree that was submitted to the Board of Appeals. Now, which tree was that in the list that you provided? Is it in the packet, or what was the 33rd tree?
Yeah, it kind of varied as the Board of Appeals hearings. We had 1 hearing in December and 1 hearing in January. It was continued to January. And if I have this whole thing prepared to show you how the trees differed from point to point. By the time we got to the place to vote, the board was supposed to vote. Mr. Bach, who was representing the department there, put up a list and said, here's the ones we want to remove. And that list contained 33 trees. The original thing before the Board of Appeals was 32 trees. That was in the Public Works order. And then somehow trees actually slipped in and out, and it's impossible to explain. But if you go to the decision posted by the Board of Appeals, you'll see we agree you can take out 32 trees And there's a list attached to that that has 33 trees. So, and there's a whole lot of missing around.
And you also mentioned that some of them were sort of edited on the day of, or
Yeah, so Mr. Bach presented a list of trees. I think he started with 34 trees. And then when the thing was continued, he showed another list up on a like a projector. Were very difficult to make out. And but I asked a public records request and got the actual spreadsheet that he used. And yeah, there were usually always at least 34 trees on that list, and not the 30 that were 32 that were originally a part of the public works order.
Okay.
It's sorry to confuse you with all this stuff, but it's imagine how I felt. I was sitting there, blindsided. So.
Okay, thank you. A question for Mr. Steinberg and Mr. Bach. So what, could you explain these errors? Are they errors in naming numbering, or are they errors that go deeper?
Yeah, I would say that they were errors in numbering, and again, Chris can give you some of the details. But as we wrote on our response, for each request that Mr. Karn submitted, we released responsive records as they existed in the tree database. He had questions about how Buff had numbered some of the trees, and this resulted in some confusion. And he followed up with Buff, and they talk a lot because he's a tree activist enthusiast, and so they do a lot of communication. And they had questions about the identification of specific trees, and our staff worked with him to answer him. So it's important to understand that the tree database is always updated if correct information, or if to correct inaccuracies or improve identification of trees. And again, Chris can talk about the numbering system. So although there may have been disagreements over the numbering and the identification of some trees, at no point did we withhold records. We gave him what we had at the time. And if it turned out that some of them were mislabeled, that's what we had then, and subsequent discussions, he's gotten the information as we've gotten it. In some cases, I think he's helped Buff better identify what some of the trees were.
Okay. So Mr. Buff.
Good evening, Chris Buck with San Francisco Public Works, Bureau of Urban Forestry. Thank you. So I would agree with Mr. Steinberg, my colleague, in that the matter before us this evening is really about a robust discussion that's been occurring about naming conventions and how trees are recorded in our tree database. There were 10 permit applications along Market Street that BART submitted that incorporated a total of 32 trees over 10 sites. So the original records request for 32 trees was completed by our clerk, a senior clerk, Cerise Waiters. Mr. Carnes, shortly after, had questions about 4 of the trees. They were showing up in a different location on his Google Maps. We had discussions about why that would be. There are 3 aspects of tree database management, and one of them is how we number trees. We number trees with the flow of traffic so that crews and trucks are more likely to encounter the trees in the row in which they're listed on a clipboard or a spreadsheet. So we go with properties on your right, streets on your left. We go low to high, and then with the double row of trees in Market Street, it adds another layer of complexity when you're trying to correct the numbering. So tree 1 would be towards the curb, tree 2 would be back of sidewalk. Tree 3 would be the next tree at the curb, tree 4 is back sidewalk. Another issue with Market Street is you might have 2 buildings, but with a plaza in between them, and that plaza is sort of open to both properties. So when you're physically on site, you may think this is 535. Well, you discover back at the office that the parcel map, that plaza was associated with 575. a lot of the discussions we've had with Mr. Carnes over the last several years is around these conventions on how we name and label trees. And so I do respectfully disagree that it wasn't, I believe his word was alter. When I discover a mistake, what I believe is a data mistake, and I'm about to present at a Board of Appeals hearing, I'm going to update that data. I'm not altering it. So the intent is always towards correct, accurate data. And to this day, we're probably still at odds on where we are with this, but we have matching PowerPoints where we've reviewed his PowerPoint and we've provided responsive PowerPoints and really gotten under the weeds with the urban forestry inspector who is handling the case, the senior clerk, and myself. So there's no conspiracy as to why those numbers change. We're literally trying to keep track as best we can how to number those trees. So that's a little bit of general background on how I see what's occurred here.
Okay, I just have, could you explain the difference between what was given to Mr. Carnes and what was presented to the Board of Appeals?
Sure, I think that's being misrepresented right now in this hearing. There have been a number of hearings. There was a Public Works hearing. There was a Board of Appeals hearing. That hearing was continued. There were 4 appellants, and Mr. Carnes was one of 4 appellants. So there were 3 other appellants who were also trying to reach a settlement agreement with BART, separate from what I was doing. So there was a lot of discussions. I need to be firm about, there were a lot of other discussions with other leaders involved. I was certainly not the person sort of controlling the strings, behind the scenes. There were 3 other appellants who agreed to settle with BART and come up with a compromise. During all of that, we continued to exchange information with Mr. Carnes about trying to answer and get down to the questions over the tree numbering. We even did a walk from one end of the BART projects to the other, and our urban forestry inspector asked Mr. Carnes, have we cleared up the numbering? So we really as staff wanted to make sure we want to have a hearing where we're all discussing the correct trees. There's no questions about tree record history. And that process occurred. When I changed a record, I changed it literally a half hour before the Board of Appeals hearing. Our staff represents us at an earlier hearing. I represent Public Works at Board of Appeals, and I found an inaccuracy. And so I have a responsibility to correct that and bring it to light. So the other appellants, never was the trees in question. The correct trees were always referenced in photographs and in site plans, BART's application. There's never any question as to what trees we were referring to. There's a lot of questions about tree numbering conventions.
Okay, so these 2 sort of corrections that you made just before the Board of Appeals meeting, were they corrections that had been addressed by Mr. Carnes, or were they in addition to them? So Mr. Carnes pointed out 4 trees that were not supposed to be on that list, right?
I think we would have to, I would need 2 hours, and you'd need to review a 50-page PowerPoint to make that statement. I think stating it that way is not accurate. We would have to go into greater detail to provide that. I made corrections. I called our urban forestry inspector who represented us, and these permits, these 10 permits with 32 different trees in all these different locations, and said, I see these tree number IDs. The appellants have agreed to settle, and they're coming here tonight to settle. It'd be great to provide this list. Here's the updated list. Part of it was still being debated. We're still trying to clarify, what are we calling tree 1 or 2? Is it 553? Is it 555? Is it 535? At the end of the day, we haven't been able to reach an agreement with Mr. Carnes on really how the trees should be numbered. And then we eventually learned that it's the latitude, longitude that he's really concerned about. So we've corrected that, and Bart's corrected that. So we're trying to address all that, but incorrect information would never be knowingly provided. All the information we've ever provided, we thought at that time was the correct, accurate information.
Okay. There's a question about the number of trees. That's what I'm trying to get at. So is it 32, 33, or is it 31, or is it like, there were a number of modifications made to the numbers that you provided, Mr. Carnes, or in his next request. So I went through each of them, and as Mr. Carnes had stated, there were 32 trees, then 34, then 33, then 31, then 32. Is that issue, has that issue been resolved in terms of, what did you vote on?
Sure. I would have to look at the details to verify that, but I mean, sometimes it was a matter of someone referring to the number of trees that still existed versus trees that had been removed due to poor health. So they still need to be captured in that permit, but they may not physically exist. Or when Mr. Carnes says there's 34, there's 33, we'd have to compare the spreadsheets and look at that and understand. What I can state is that the Board of Appeals had a total of 4 appellants, a continued hearing, an extreme amount of public review of this with a lot of other tree advocates. And Board of Appeals also heard the case and had to make findings and had to discuss and review the list. There's also the opportunity to request a rehearing. So again, through all that process, we were still trying to work with Mr. Carnes. Our goal really was to try to clear that up so we could be at the hearing and feel like, okay, we could still disagree on the merits of the case, but at least we could put to rest some of those questions around the numbering.
Okay, thank you.
Sure.
Member Hill?
Hi.
Hey. Sure.
Thank you for your testimony. Is it a correct statement? So the way I'm sort of seeing this is it a correct statement that you've essentially been in partnership with Mr. Carnes, and in your original request, like there was an admission that there had been an error, and that you've been working in partnership to correct that error, and it's in those conversations and partly those conversations that led to the different outcomes for the different requests.
Correct, and certainly there are moments, I don't want to mischaracterize it. There absolutely, as our colleague David Steinberg with the director's office stated, Mr. Carnes is a tree advocate. There are a lot of things we probably agree on 95% of the policies in the city. We love trees and we want to see the urban forest plan enacted. But there are going to be times when we disagree about tree numbering. And so we have, this is certainly not the only case where we had questions about tree numbering. So he brought up an issue with some tree numbering on Junipero Serra Boulevard, where he was really focused on the XY coordinates. And I have to tell you, I've not sent someone out to go tree work based necessarily on XY coordinates internally within our own tree crews. So when information is brought to us that needs to be updated and corrected, we absolutely want to update that information. We've had robust discussions about sometimes whether does that mean we need to restart an appeal process all over again? Do we need to republic notice something? Was the public in some way impacted by that correction? So there was a lot of discussion. I was out on 4 months leave. So on that August 26th date, I was just back from a couple of heart attacks. Second evening, back at work, I wasn't sending emails out in someone else's email address. So I was catching myself up on where we are. We have 10 permits, 4 appellants, 32 trees, multiple trees with different numbering. So it's not easy, but we love what we do. We love accurate data, you know, and our current directors are former urban foresters. So we really care about this. So I would call it a partnership, even if sometimes it may be a little strained.
Sure. Thank you. I'm actually trying to find the original public records request. Is that in the package?
Yeah.
Because I like because I know I see that there's information about because the request was I requested a list of trees from Public Works per their removal order number 205249. But that wasn't the actual original request. That was just.
Yeah, that was the original, that page 79. Page 79.
Oh, sorry. I'm looking at page 7. Sorry. Thank you.
Oh.
Give me just a moment.
Um,
Thank you. Let me just get there. Page 79. So I'm looking. It sounds this page.
So,
Is that the right page? 'Cause I'm not looking for the reason why I'm asking the question is I'm just trying to understand what the language of the original request was, not the complaint that was filed to the.
that's on next request also. So he's given several numbers on next request.
I have it here.
It's okay. Okay.
But it was specific to what was interesting is that that Public Works director's order was a single director's order that encapsulated or condensed 10 different orders. So we actually put 10 different resulting permit decisions into a single order to try to facilitate streamlining of appeals.
Right.
So that was us trying to make it easier for the public to appeal. But the request was for the for the 32 trees listed in Public Works Order 205249, provide a San Francisco tree information report for each. So what I want to point out is that the tree numbering is actually not mentioned in this order, just the whether it's tree 1, 2, 3, or 4, let alone individual tree IDs. So I will say in my senior clerk's defense, she had to go into 10 permits and figure out tree 1, tree 2. It's not like myself and Mr. Carnes had for her a list of the 32 tree IDs, which are like the social security number, and said, hey, here's those 32 social security numbers, get us those records. She has to go and sort of do that herself.
Right.
So that is something that I noted in this, that the original request, you know, it was a fair request. We thought we had the right 32. And when we discovered 4 we thought, Mr. Carnes thought 4 were inaccurate, that's when the whole question about what we're referring to those other 4 trees. Is it at this address? How are we numbering it? But that was the language.
Thank you. And I just looked it up on next request, and
Sure.
Yeah, it's for the 32 trees listed in Public Works Order number 205249, provided SF tree information report for each.
Correct. And they weren't literally listed as individual tree IDs. It was like, it said like 2 trees at 383 Market. So again, that was our senior clerk just doing the best she could. And then once we received questions from Mr. Carnes, we tried to figure out, okay, what are the 4 trees that he's looking for? And that's when he presented it's not mapping out right, you know, and we kind of tried to figure it out from there.
Thank you.
Yeah.
Do you have any more questions?
No.
Okay. So maybe we could go to rebuttals. Mr. Steinberg.
I really don't have much else to add. As I said, you know, we released the records that we had in a timely manner. We released what was in the database, and we were, I hate to use the term, but, I think in good faith, we turned over what our records, well, we did turn over what our records were at the time, and which we believed were accurate. If there were any errors, then, as they were cleared up, we communicated with Mr. Carnes, but I can't really say much more than that. So,
Okay, thank you. Mr. Carnes, maybe a quick wrap up?
Sure. I'd like to rebut, some of the things Mr. Buck said, and then we can wrap it up. Will it be okay?
Yes.
Yeah. So I wondered if you could put up slide 6, please. Can you sail through the first?
Victor, if you're able to put up slide 6 from the presentation, if you're able.
And then while you're doing that, maybe you could also pull up slide 21, but maybe have that queued up. It's a different video. That's Mission Verde. It's not something I supplied you.
No.
The file I gave to.
Wrong file?
I think so. Yeah, that's a really nice project. It's called Mission Verde, where Department of Public Works
Give me a
chopped
moment.
down, a whole lot of trees, and neighbors got together and replanted the area. So, but that's nothing. I mean, I love that project, but that's not why I'm here tonight. That's not why we're here tonight. So maybe you could help them look for. Let's see.
That's not it.
I can just show you. Let me just hold it up here and show you. It's you've seen Google Maps, right? Where they, I don't know if you have, but if you have a set of coordinates, longitude, latitude, you can slide them into Google, and it's a free service provided by Google. And you get actually, I don't know if you can see this, but it's a picture of Market Street.
Mr. Carnes, may I interrupt you? Is it part of the packet?
I believe so.
Okay, maybe we could locate it on the.
I see it. Thank you.
Yeah.
It's 53 in the PDF, page 53. So 53 here, but 109 at the bottom.
Okay, good. All right, we have it.
Okay, sure. So the reason I asked for, in my request, I asked for tree IDs is that with a tree ID, you can go in and get the exact longitude, latitude. And just to explain that, in 2017, the city of San Francisco spent $500,000 surveying all of the street trees in San Francisco. And one of the first things they did is they go up to the tree and push a device like this, and it says longitude, latitude. So that's slid right into the database. And so I like to use that because that's a lot more accurate than 555 Market Street, Site 3. And in fact, it's something they do. It's called a removal hearing. The person who's a specialist for Market Street misidentified several trees because he didn't know the site numbers. So anyway, why would you want to use site number and address when you have longitude, latitude? And then if you're looking at this map, you'll see that I took the trees that Buff gave me and I mapped them. And at the lower left of the slide, do you have it in front of you over there?
We do.
Yeah. So at the lower left, you see it says subway entry. So any trees that were like numbered 1, 2, 3, 4 around the subway, if they were too close, they'd have to cut them down to put the cover on. But if you look up towards the upper right-hand corner, you see 553 Market and trees 1 and 2. Now those are the 2 trees they gave me that were just totally wrong. And you can kind of see it visually here. So, but I just wanted to, impress upon you, the city spent a lot of money getting this done. In fact, some of the tree experts in New York said, wow, that's one of the best surveys I've ever seen, but a little expensive maybe. So, yeah. And also, when you talk about BART, the BART engineers really had no idea where the trees were. And I met these guys. They're very nice guys, and I really enjoyed working with them. They were scientific, and they understood longitude, latitude, and it was, you know, I'm still friends with these guys. And what they did, one of the guys, one of the chief guys, Mark Dana, said, well, can you send me something? So I did. I sent him all the trees along Market Street, and he actually superimposed them over a picture they had of Market Street. And they said, God, thanks so much. You know, we're trying to rely on Buff, and they had trees, you know, all over the place. So anyway, that's
if you could wrap.
that was very pleasurable for me to work with guys who were engineers who understood, you know.
All right, I think time's up now.
Okay.
Do we have any more questions?
Oh, I say I have a total of 3 minutes. Huh? Okay. There's one of the slides that's kind of good, but we'll.
Just to clarify, you received all the records that you were looking for, but they were inaccurate. Is that?
Well, yes. Of the 30 trees listed in the original order, the DPW puts out an order, and they say, you know, 3 trees at 555 market and 3 trees at 595 market. That's very difficult to find those trees to see, you know, what their condition is and whether you want to cut them down or not. So I asked for, and it shouldn't be a big problem because I've asked for tree information sheets for years from Public Works, and they're saying now it's a big problem. It's never been a problem before. I give them an address or whatever, and they send me the tree information. So if I sent them something, I said, send me the information for tree, you know, 555-1, they would be able to do that. And on the top of that sheet, that tree information sheet, it gives the tree ID. So I short-circuited that. I just said, give me the 32 trees by tree ID.
And so are you looking for any more information from them at this point, or do you have everything that you requested?
This case is long gone. It's they arrived at a fairly good solution. I'm just very hesitant to, whenever I look at records from Public Works, your urban forestry, they're abysmal. They don't use the $500,000 survey. In fact, they tried to suppress it for some reason, I don't know. And I've gone to various hearings with Mr. Buck, trying to explain that, you know, that longitude, latitude is the way to go. And I don't think he still understands that. So. And I think another thing was, and I mentioned.
I think
we're over.
We have what we need at this point,
Okay.
Mr. Carnes.
Yeah.
You know, so it's now we will take a few minutes to kind of discuss it between us. So I think the only thing we can look at the moment is records, the public records. And it seems Mr. Carnes has received everything he asked for.
Yeah, I would agree. I think that I've certainly learned a lot today about numbering trees.
Yes.
And I appreciate the education. You know, and I also just really appreciate the partnership that I think that feels like exists. Although sometimes, I mean, we on the Sunshine Ordinance Task Force, we also have partners, you know, who are citizens that help us, you know, when we need the additional help. So, you know, to Mr. Carnes, you know, I really appreciate your advocacy. I think that's part of why we have a Sunshine Ordinance. You know, is because you know there are humans that are working on this inside of government agencies, and we need that oversight from the public in order for us to be able to get to accurately represent our community. I feel like that. I looked at each one of the individual requests, and it looks like each one of the individual requests were fulfilled. Now there might have been mistakes in those requests, and I also feel like that, so far, the Public Works has performed in good faith in order to rectify those. But we're not here to actually decide quality.
Yes.
We're here just to decide whether that they fulfilled the request, and I believe they have.
So the only thing I would say with quality is that in a complete or timely manner. So the word complete is there. So so the only issue I might have is lack of accuracy in the in submitting the records to Mr. Carnes. But at this point, I'm not clear if Mr. Carnes is looking for anything more from them. So if it were to go to the task force, I don't know that Mr. Carnes is looking for any more records. So we're at that point.
Right. And so just a point of clarification, in this case, are we still making the recommendation to go to the board with our recommendation?
Yeah, I think we will make a recommendation to go to the board. Would you like to go ahead and make a motion?
Before I do, I just want to ask a question of you. So do you feel like that, I actually feel like that our recommendation is that we feel like that Public Works did respond
Yes, in a timely
successfully.
manner.
Correct.
Yes.
So yes, I would like to make a motion that we take this to the full board with a recommendation of non-action.
The records are public, and that the SOTF has jurisdiction. So we need to mention that.
Oh, okay. Yeah, that we do have jurisdiction to decide on that.
Yes. Refer the matter to the task force.
Is this going to be on would this be something that would be on consent, or something that would be taken up by the board?
So Cheryl, should we?
Yes, I think since all parties have pretty much agreed to
Exactly.
where they stand, the records are provided. There were no arguments about that. It seems to be a discussion about just accuracy with the longitude and latitude and the actual identification of trees.
Which that's not really our jurisdiction.
Consent would be.
Yeah, this would be a good opportunity for consent calendar.
Thank you for that clarification. Yeah, so I'd like to make a motion that we do have that the Sunshine Ordinance Task Force does have jurisdiction, and would like to move that we place it on the consent agenda of our next meeting.
And I would second that.
This is Victor Young. The only thing is, if you do send it on to consent, you do need to figure out if there is a violation or not that both parties are agreeing to. Or are they finding that we don't have jurisdiction over the matter as it's the documents were provided?
So I do believe we have jurisdiction, but in terms of violation, I could ask Mr. Carnes if he feels that there was a violation of the completeness. Mr. Carnes, do you feel that there was a violation in terms of completeness?
I do. There were so many errors, but I have a slide if you want to look at it.
Before you do that, I just want to caution you that we are only looking at records. We're not going to be looking at the email information that you provided in the agenda because it does not fall within our jurisdiction.
Yeah. Okay. Well, if you could just one quick thing that'll show you that the records were not adequate. Slide 21, please.
Um,
I guess the question is, I personally feel like that, like you have a complete and accurate picture. Am I incorrect in that assumption?
I
That-
don't. No, that's incorrect.
Oh, okay. All right. Thank you.
Yeah. So, but I just wanted. This is actually a response to Mr. Steinberg's objections. If I could show you the my answer to that.
Is this the page that shows 553 Market Street, trees 1 and 2? No.
553 Market Street, tree 1.
So we have it in our packets. So
It's number 21.
yeah.
Well, it looks like a sawhorse,
Oh,
and then a looks like a sawhorse, and next to it is a mini bus station. And actually, I'm not sure. Let's see. This came in subsequent to the response from Mr. Steinberg only came in maybe less than a week ago. So. I thought Ms. Leger told me to send my information to her and to the opposition, which I did. And then they wrote
okay.
a bunch of objections.
We have the agenda with everything that you sent, I think. I'm just not able to locate the page that you are, so.
Well, this page only came in, I mean, I prepared this since Mr. Steinberg sent his objections,
Which,
which only came, I don't know, would you send those like 5-6 days ago?
So it's
okay, so it may not be in the packet.
It's probably not. I mean, if the
Okay.
packet was assembled with
5
last
days,
week,
yeah.
it wouldn't be in there. Yeah, but I just wanted to say that I got a request from them that said everything was copacetic. There was a sunshine request 22-994, which I claimed there were problems with, and they came back with this statement that 553 Market Street, tree 1, was okay, and the records request 22-994 showed an image that they had filed, 553 Market Street, tree 1, which you see has I don't know, you can't see it, but it has a tree that's been removed with a sawhorse in the middle of it. And I have a recent photograph of 553 Market Street, tree 1,
There it is.
with right next to a mini bus terminal. And I actually went by there a week ago, and it was still there. So the cut down tree and the reality of that place don't agree. So
okay.
would you?
All right. So, so I'm still unclear, Mr. Carnes. So you are still looking for more information from them, or are you not?
Well, the thing has been settled, I believe. So.
The thing has been settled. Okay. So are we in agreement that the issue has been settled?
I'm not, but you know.
Okay.
So
What might be an example of something else that you'd be looking for from this public records request?
Let's see.
The last request that I'm looking at says an immediate disclosure for the trees listed in Public Works Order 20529, provide an up-to-date SF tree information report for each. So that was the last request that was 22-992, an immediate disclosure request for the trees listed in Public Works Order 205-249, provide an up-to-date SF tree information report for each. So I'm assuming that you did get an SF tree information report for.
Yes, there's a listing. I think
Yes.
there's a picture of it here, where I,
So that's
I
fine.
did get the, and that's when I discovered that 4 of the 32 trees
That's
were not valid.
Okay,
Okay.
thank you.
All right.
Yeah.
So where are we at right now? We have a motion on the floor, so I don't know that can go to the consent calendar. I think we still need to send it to,
Well, I mean, if you agree, if what you're saying is that that we still need to get clarity on accuracy, then yeah, then I would agree with you. I guess that was my sort of outstanding question is that,
Right.
I mean, I feel like that like each time that the request has been made, that that had been filled as accurately as it could have been at the moment. So that's my question to you is, and I'm sorry, like we can discuss this amongst ourselves, right?
Right, yeah.
It's my first time being in an in-person committee hearing, so I want to make sure that this is okay. Okay. Yeah.
So, yeah, I do believe that even on next request, there were several,
Yeah, I did look through each one of them.
yeah. So there were several edits made to the release of records. The fact remains that the records were released. They were inaccurate, but they were released on time. So we come down to that at this point. So I think we should,
Okay. I'll remove my motion.
You want to revise it?
well, let's revise it.
Yeah.
So I think we should just send it to the task force with the recommendation of
Are you being to further investigate accuracy, or because that's it's sort of subjective, I think.
Yes.
Yeah. For us.
I think we should send it to the task force with our recommendation that we don't find any violation at this point.
That
Yeah.
I'll second that motion.
Yes.
And
I
we're
move to
not-
find that the SOTF has, so I'll make the motion now?
Challenge is on the floor.
Okay, it's on the floor, so you have to go ahead. and
Okay,
do
I'll
that.
amend. I'll restate the motion that we find that I move that we find that the San Antonio Task Force is this is within our jurisdiction, and then we find that there has been no violation.
That the records are public.
The records are public.
Yes, that the records are public.
And to refer the matter to the task force.
I'd just like to add that maybe you should put in that you recommend that the task force find that there is no violation.
Yeah, that is my motion. Yep, I did say that.
So we're going to open this up to public comment.
And I'll second that motion. Yeah.
Sorry.
Okay, if there's anybody in the room who would like to make public comment, you can approach the podium at this time. If you're on the telephone and like to make public comment, you can go ahead and press *3 to raise your hand and indicate you would like to make public comment. And I believe we have one person online with their hand raised. I believe you're already unmuted. Mr. Pelpel, are you still there? Okay, the person with their hand raised is not responding at this time. And there is no other persons with their hands raised at this point in time.
Okay, should we give that person another minute?
Okay, I just made them a panelist just to see if we can get their attention. Caller, you are unmuted if you'd like to make public comment at this time. Okay, we're not getting any response at this time.
Okay. All right, we can close public comment then.
Move to a vote.
Let's go for a vote.
Member Hill?
Aye.
Member Hill, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Chair Hyland is absent. 2 in favor.
Awesome. Thank you.
Thank you.
Thank you very
to all
much.
parties.
And I'll just say again to Mr. Carnes, I really respect and appreciate the work that you're doing as a citizen advocate. Please continue to do this really important work, and also
you.
to you both as well. Thank you for the work that you're doing.
Are we ready for the next item?
Yes, please.
Item number 6, announcements, comments, questions, and future agenda items by members of the Education, Outreach, and Training Committee.
I don't have any announcements.
Neither do I.
All right. So maybe we could go on to the next item.
Item number 7, adjournment. I have 8:06 p.m.
I'm sorry, David Pilpel, can you hear me okay?
Yes, we can.
I'm
But-
sorry, I was making public comment at the meeting next door to you in room 416. On the previous item, I wanted to speak in support of the motion to forward the matter to the task force with a recommendation to find no violation of the Sunshine Ordinance. I think that was clear. I think that's what you had, and I'm in support. Thanks very much for listening.
Thank you.
Thank you, David. I move to adjourn.
And I second it. So this is the point I use the gavel.
You have to use the gavel.